Rob Clementi, the Chief Executive of TEN, the Education Network. Kimberley Martin from WWM Law in Hobart is presenting a major paper on digital currency disposition at our 10th annual Wills and Estates Conference on the 16th and the 17th of February in Melbourne. Kimberley is with me today for a sneak peek at what she plans to cover in the presentation. Kimberley, thanks so much for joining us. Crypto really has been in the media recently, a lot. What are the key things we should be saying to our clients about it?
So Rob, I think one of the most important things that we should be saying to our clients is raising cryptocurrency, raising crypto assets generally with our clients, because one of the biggest mistakes that we can make as practitioners is to not have a basic understanding of what crypto is, what types of crypto assets there are, and why we should be discussing it with our clients. I couldn't imagine a situation where we didn't ask our clients about the types of real property that they owned, or if we were administering an estate where we were going to deal with various asset classes, we wouldn't talk to the client about the cost base of those assets or how we would sell those assets. So from an estate planning and an estate administration point of view, it is vital that all practitioners are talking to their clients about whether they have any type of crypto asset, and if they do, from an estate planning context, talk to them not only about the legal plan for those crypto assets, but also the access plan for those crypto assets. And what I mean by that is it's fine to prepare a power of attorney and a will disposing of assets or authorizing somebody to deal with assets on your behalf, but that's the legal plan. With crypto assets, a legal plan on its own is not sufficient. We also need an access plan because of the additional steps that are needed, the additional information that a fiduciary, an attorney, an executor is going to need to be able to access any type of crypto asset. The private keys, the seed phrases, that sort of information, which as part of the access plan, we should be talking to our clients about where it's stored, how it's stored. Because if we don't plan for it, or if we don't know that it exists, if we know it exists, but we don't have those access details, that those cryptocurrencies, the Bitcoin, the NFTs, they might be lost. We might not be able to access them because we don't have the keys necessary in order to gain access and take control of them. And that could be a huge loss. Now, despite the fact that cryptocurrency has been in the media a lot recently, a lot of that's to do with the exchanges and the way that they are being run, and the fact that it's not necessarily regulated in the way that it should. I think that there is definitely a place for crypto assets in the future. I don't think it's something that we can ignore, or it's just going to be something that goes away. And so we can't stick our head in the sand and think that that's the case, because our clients in the future will expect us to be able to give advice on this area. And that's very much a summary of what my presentation will talk about at the upcoming conference. In that, I will go into detail about the estate planning considerations, the estate administration considerations, and really the legal plan and the access plan and what they look like.
Kimberley, thank you very much. That was a fascinating introduction to what you plan to cover. And I think your point, particularly about access, is critical, because there are hundreds of millions, if not billions of dollars of crypto which have literally been lost because people have lost the key, lost the password, or what have you. Now, if you would like to hear more on this very important subject, you can register for the conference by going to the website www.tved.net.au. In the meantime, thank you so much for listening.